Hello and welcome to CCLS. I'm Miriam Goldby and I'm here to introduce you to the Marine Insurance Law course. Insurance transactions have as their purpose the transfer of risk from the assured to the insurer. This means that the assured receives compensation from the insurer if the relevant risk comes to pass during the contractual period and causes the assured a loss. This is because by entering into an insurance contract, the insurer agrees to protect the assured against defined risks. Shipping is and has always been a perilous business, involving risks as diverse as adverse weather conditions and currents, piracy, collisions, groundings, and damage to or loss of cargo. Insurance as a risk transfer technique was originally created precisely to support maritime activity. This module deals with the law of marine insurance applicable in the UK, which has been to a large extent codified in the Marine Insurance Act 1906 and deals with numerous issues. First, the module covers the definition and formation of a marine insurance contract. Formation requirements include compliance with the duty of fair presentation of the risk and insurable interest. There are also special rules determining what constitutes evidence of the contract and its terms. Next, the module deals with the various risks covered as well as those commonly excluded. The rule of proximate cause, the diverse forms of loss that a vessel or cargo owner might suffer, the notion of indemnity, and the rules governing assignment of rights. Finally, the module discusses claims under the contract, including the process of making the claim, the post-contractual duties of good faith, subrogation, and contribution. Throughout the module, there is a focus on the London insurance market, a market that is over 300 years old and still one of the most important insurance markets globally, especially for marine insurance. Some of our contributors have also authored important scholarly works in this field. The way classes are conducted for this module is adapted to the number of students taking the module in any given year. Usually it tends to be seminar style and highly interactive. Participation in the discussion in class helps students to prepare for their final assessment and provides them with instant feedback. Preparatory reading and exercises are set prior to each class. The module is assessed by in-person exam. Certain materials, for example the text of the Marine Insurance Act, will be permitted, and a copy is usually attached to the exam paper. Students will be required to answer 2 questions out of a choice of 5. An opportunity to practice answering an exam question will be provided, and students who submit a practice answer will be given detailed individualized feedback. This style of assessment requires students to develop the ability to build persuasive analytical arguments, an excellent transferable skill for any legal practitioner. Insurance is essential to all commercial activity because it is a prime method for managing risks that can hinder commerce. A career in insurance may not be a first choice for many students, but those who choose to take this module acquire a rich understanding of the law governing the transfer of risk and develop expertise that is very much in demand, not least in the world of shipping. Thank you for listening, and I hope to see you on the module.